Welcome to Absolute Trust Talk with your host, Kirsten Howe. Absolute Trust Talk brings you tips, tools, advice, and interviews to help you build a reliable knowledge base on estate planning, business, and finance to start preparing for your future today.
Hello and welcome to Absolute Trust Talk. This is our podcast, our live streaming on social media podcast at Absolute Trust Council, and we're very glad you're here to join us. As probably our listeners are at least vaguely aware, California is what's called a community property state. And that means that there are laws that tell us, for instance, what someone can and can't do with their community property, what happens in the event of a divorce or a death with community property, with separate property. And so as you can imagine, when someone has community property and separate property, we have to plan their estate plan with all of that in mind. You can only plan for what is yours. So married couples need to understand what is community, what is separate, and how are we going to fit this all together in an estate plan. And we are going to tackle this topic today, and actually probably in 2 episodes. There's just a lot to talk about. First part, we're going to talk about what is community property, what is separate property, and what are the planning considerations that we have to keep in mind when we're working with families who have both. And the second episode, I hope, we're going to be talking about some of the failures to plan, some of our horror stories, and the undesired results that we've seen and how we fix them. Today, I am very fortunate to have one of my very experienced, very knowledgeable estate planning colleagues, which is really fun, here to talk with me about this topic and how we plan with our clients who have both community and separate property. My guest is Ruth Koller Burke, and she's a partner at Koller Herlihy LLP, which is here in Walnut Creek. Ruth has more than 25 years of experience, and she provides legal services related to estate planning, trust administration, and probate, just like Absolute Trust Council. But she has a very unique blend of experience as both an estate planner and as a litigator, which we don't have at Absolute Trust Council. She's been involved with the preparation and trial of hundreds of cases representing Fortune 500 companies. So she really knows that side of the world. And I think that experience really helps her in her ability to help clients navigate in those contentious family situations that actually, come up from time to time in a trust administration or a probate. Ruth graduated from Santa Clara School of Law, and she has a Bachelor of Arts from UC Riverside in political science and public service. And before she formed her partnership, Koller Herlihy, she had her own law practice, and she was a tax consultant at PricewaterhouseCoopers, which is very impressive pedigree, Ruth. Welcome, Ruth. I'm so glad to have you here.
Oh, thank you for the nice, kind words and introduction. It's an honor to be here today and get to speak with you about what we do and what we see every day. Thank you.
Great. Okay. So as I said, we're going to talk about community property, separate property. Before we go into it, let's just make sure everybody's, understanding this terminology that we're using. How do we define separate property and community property?
So at a really high level, separate property would be your assets you acquired before you were married and anything you inherited or were gifted during your marriage. But what you earned during your marriage, such as your job after you're married, those earnings would be considered community property.
Right. Okay. And also, I guess it's important to point out, I'm not sure how this is going to come up in our conversation, but when you have separate property, the income, what that separate property generates is also separate property.
Right.
Okay. So that's the law, but couples can rewrite that law for themselves if they think that that's a good thing to do, right?
Right. Right. Well, it's interesting because I think most people, when they think, oh, wait, I want to make sure what's mine is mine that I'm coming into the marriage with, that would be a prenuptial agreement. Right. And then there's agreements that can happen after the marriage. But I think what's interesting to focus on this conversation and what we do is that most of my clients, when they're contemplating the prenuptials or postnuptials, it's in contemplation of a divorce down the road versus what we do. And they almost forget the whole estate planning part of it. They're just worried about that. And then they're not getting through the steps of making sure the plan is consistent with what they've put forth in the prenup or postnuptial.
Yeah, that is a good point. Do you in your practice do prenups or postnups?
Very rarely. I think when a client comes to us to do estate planning, we would have them sign a conflict of interest waiver to do their estate plan as a married couple. And in my opinion, the prenups and postnups, the individuals signing them should have independent counsel. Every once in a while, we'll get involved in maybe something after they're married that was separate property, transferring it to community property. But in general, for a formal prenuptial agreement, postnuptial agreement, we would refer them to counsel, and then they'd come back to us with that agreement in place.
Yeah, we handle it pretty much the same. I do not do postnuptial agreements. I don't do prenuptial agreements. We refer them to a family law attorney who's familiar with, because those agreements require very specific formalities. Otherwise, they are not, legally enforceable. And
Right.
So I don't want to mess with that. I don't know the family code. I don't know all the case law, but the family law attorneys do.
Right, exactly. And they're dealing with those unwinding and being a part of a divorce procedure. So they really know where, that the pitfalls are in a different form that we may not know as estate planning experts.
Right. And like you, I will occasionally do a little thing around the edges. Like what I'm thinking of, the most common example I can think of, let's say during the marriage, one of the spouses inherits a piece of real estate. So that's separate property under the law. But for a variety of reasons, including tax, they might want it to be community property. And that's what we call a transmutation for the, nerds out there. And it has to be done in writing. So a little thing like that, I'm willing to do in the right situation. But you got to warn that spouse, if you do this is for real. You can't undo it. And if you get divorced down the road, it's half and half. So
right. Or if you have kids from a prior marriage, they may not appreciate what you're doing.
Yeah, that's another good point. Yeah. So I stay away from the prenups and the postnups, but I will do that little bit, a little tiny transmutation here and there in the right situation.
Right.
Especially if they come in and they've been married for 75 years or something like that. Like, okay, they're probably not going to get a divorce.
Right. Well, and I think, we're trying to put these estate plans in place that, don't have any cracks to them, any openings for people to question what was done. And so that prenuptial or postnuptial document really serves as the foundation for it. So that needs to be solid.
Right. Absolutely. It's kind of funny. I've had a number of cases where a married couple comes to me and it's their second marriage, for maybe on both sides. And they've been married the number is funny. They've been married about 8 years. This is very common thing. I don't know if you've seen it or it's just me. They've been married 8 years and now they're going to do estate planning together for the first time. And I'm talking to them about what they have, when do they get it, what's separate, what's community, what in their minds, what's separate, what's community. And they've kind of mixed things together, oftentimes inadvertently, like they don't appreciate that that's a commingling, they're mixing things together. And then we have to send them out for a postnup to untangle it before we get going.
Right. Exactly. It would be somebody buying the, vacation home, the condo in Tahoe, and buy it was the down payments with a separate property asset. And then they start using community funds to pay the mortgage, pay the property taxes, put on the new roof. And it's just morphed into a commingled asset very easily.
Yeah. And it just didn't occur to them that by using our wages, we're making this separate property asset a community. It has a community component to it.
Right.
So that's a thing that we have to get clarity around. In order to do the planning. When you are working with clients who have maybe each spouse has separate property and they have community property, are you talking to them about, we're talking about trust planning. How many trusts are advisable in the situation?
Right. That's really interesting. And I think it's very specific to the clients, the assets, the duration of the marriage, if it's a second marriage environment. If it's a second marriage and there's separate property, I often, if there's kids from the first marriage, I'll lean towards each of them having their own separate property trust and one community trust.
Yeah, I agree with you. I think it varies greatly depending on the client's situation. But sometimes there will be 3 trusts for a married couple. Their husband has a separate property trust, wife has a separate property trust, and then a community trust. And I don't mean to be, heteronormative. That's just shorthand for one spouse, the other spouse. Same would be true for a same-sex couple. But it can be done in one trust. And I think that probably you do that sometimes too.
Right. Particularly first marriage.
Yeah, exactly. You don't have to be a blended family to have separate property.
Right.
You could just come into your first marriage with separate property. And there are no stepchildren. All the children are of the 2 clients who are in front of us.
Right.
Sometimes it makes sense to keep it simple.
Right.
With just one trust.
Right. And for those clients, I see the distinction of separate property and community property. Really, their intention was in the event of a divorce, because when they pass, they intend everything to go the same direction. Right. So those estate plans to do one trust that holds separate property of each spouse and the community property, I think makes a lot of sense.
Yeah, that's a really excellent point, is especially when the plan is I'm leaving everything to my spouse, whether it's community or separate. Really, do you need to mess things up or complicate things by having a whole other trust? Right. Probably not. Yeah, that is a really excellent point. Okay, so when we are using just one trust and we're putting some of it separate, some of it community, one of the problems that I worry about is, like we can list on separate schedules, this is husband's separate property, this is wife's separate property. But then when they go to actually fund the trust, the account numbers change, or years and years go by and what used to be a Schwab account has become a Fidelity account. And I worry about. What do you think about that?
I think that is where it starts to get challenging to have the one trust, because if you don't have the funds going, if the funds are all going to the same beneficiaries in the same proportions,
then it still doesn't really matter.
It's moot. But when it starts to be the different beneficiaries, because as we know, people don't come back, and it may take them years to get their plan done. As you said, 8 years for, it takes them years to get it done. And then they go and open new accounts or change banks, and that schedule gets stale.
Yeah. I have seen, though, in some situations where the financial institution will allow them to actually name the account, like, let's say it's Schwab. I'm making that up. I don't know if Schwab does this, and the title on the account will be the, John and Mary Smith Trust, separate property of John Smith. It'll actually be indicated right in the title on the account. Wow. I have seen that, which, if people could do that every time, that'd be great. That'd be great.
Wow. I haven't seen that. I'm going to look for that now.
Yeah. It's only occasionally, maybe it's only certain institutions will do that. And I haven't kept track of that. I don't know, but I have seen that. So.
Right. And I think then that's when, if somebody comes to you with a trust administration after somebody is passed, that's sort of where we come in and try to help the family sort this out and get a solution if there are different beneficiaries, and try to sort out what's where, and just try to get everybody on the same page without exploding litigation.
Yeah, that's where it actually, that's where the rubber hits the road, is in the trust administration, when one spouse has died and now we got to figure out, maybe it's everything to my spouse and it really doesn't matter. But yeah, that can be a challenge.
Well, because in the circumstance where it doesn't go just all to the surviving spouse, if we have to fund a bypass trust, that would typically be funded exclusively with the separate property of the decedent plus their share of the community.
Right.
So what do we fund that with if it's unclear? What is truly the separate property?
Yeah. And then if the assets aren't really clearly labeled, how do we trace that all the way back? That could get complicated. So anyway, I guess the point is, if there's not a prenup or postnup or things got murky, we got to talk to our clients about this. We have to say, these are the possibilities and you need to be aware. We're doing our best to make it as clear as we can.
Right.
Because we certainly don't want your children fighting down the road. It's not good for anybody. Okay. Well, thank you, Ruth. As I said, there's much more to talk about on this topic, and we will in our next episode. But thank you for being here. I really, really enjoyed talking to you about this topic.
Thank you.
Okay. And so watch for us in a future episode. We're going to talk about some of our horror stories. Thanks for joining us.
Great.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.
This podcast is not meant to take the place of legal advice from an attorney and does not create an attorney-client relationship. If you do have a legal question or issue, please consult with an attorney.